I'm Matt Lewis, and we're back with Larry Beckham, a benefit review officer from the Division of Workers' Compensation, discussing benefit review conferences. And in our last video, we talked about what a benefit review conference is and what happens there. And in this episode, I'd like to discuss, what should an injured worker do at a benefit review conference that's good? I mean, what are the best things that they can do in order to help reach an agreement of some kind to resolve their dispute?
Well, some of that will depend on what the actual disputed issue is. It could be they need to bring medical from their treating doctor if the carrier is disputing compensability of the claim, for instance, or off work slips if they're disputing that he's got disability. The main thing a worker should do is listen to their attorney, because an injured worker can shoot themselves in the foot. They talk too much or say the wrong thing. So it's very important to answer questions that are asked of you, but don't volunteer information, in my opinion.
I think that's always been a problem when people talk too much. They sometimes, I've seen people talk about the vacations that they have planned, yet we're in a benefit review conference arguing over whether they're able to work or not. So when that kind of stuff comes up, does it cause a problem with reaching agreements?
Maybe not necessarily reach an agreement, that issue, but I would caution them to complain about their employer. That's the thing. Don't complain about your boss or your employer. The issue is compensability. It's whether you got hurt or not. It's not whether your employer or your boss was a nice guy. So be careful what you say in a hearing, because it could reflect poorly on you.
What about like evidence? Is that necessary at a benefit review conference?
It's helpful. You're there to convince the carrier that your position is correct. If you can do it, we can get an agreement. But if you can't convince the insurance carrier attorney, if he thinks he's got a shot of going and winning at a contested case hearing, we won't get it resolved.
Well, what kind of evidence should an injured worker bring with them if they wanted to convince that insurance company lawyer that they're right?
I'll go again. It depends on what the issue is. If it's compensability, you want evidence that, say, a witness statement that somebody saw you fall off a ladder, or fall down, or lift the box and grab your back, whatever it is.
What if the issue is like extent of injury? So the insurance company says, well, we're not accepting your injuries. We're accepting a sprain, but you have these major back injuries called herniated discs, and we don't want to pay for that.
Medical. You have to have medical from your treating doctor. And he needs to explain how the mechanism of injury causes these conditions.
What if it's an argument over your impairment rating?
You should have an alternative.
What's an alternative?
You should have a report from your doctor, for instance, that explains what the correct impairment rating is, or what the correct MMI date is. That's the first thing. And you're going to have to show that the designated doctor, if that's what is in dispute, is wrong. It's not that you have another one. It's as much as the designated doctor has to be wrong. And if you have somebody can show you, or maybe an ombudsman, certainly an attorney, can explain why the doctor may have used the wrong charts or didn't do it right.
Thank you, Larry.